Good afternoon, and welcome everybody to today's lunch hour lecture, which is going to be given by Professor Maria Lee. But first of all, I'd like to trail Thursday's lecture, which is going to be given by Dr. Jason Lotte, the Mathematics Department, and his subject is Adventures in the Seventh Dimension. Professor Lee came to University College in 2007, so as a professor, so she's been here for 10 years. Prior to that, she was at King's College and the University of Central Lancashire. Her main research interests lie in the law and policy of environmental protection, and she is particularly interested in areas of high technological complexity and controversy. So I think we'll have a very interesting lecture. After she is finished, there'll be time, I hope, for some more questions. And if you do have a question, please put your hand up, but you will need to speak with a mic. Also, we have Slido, and Emma over there will be dealing with it. The event code is 9753. Professor Lee.
Thank you very much. To make lawful decisions, decision makers have to know things, and sometimes they have to know things that are quite difficult and controversial. And landscape, I think, is one such difficult and controversial thing to know about. How do we know enough about landscape? What landscape is? What landscape will be after certain developments? How do we know enough to make decisions on it? Now, this lecture is part of work I'm doing with colleagues, some of whom are here and just gave me a nice wave, which is nice. Part of work I'm doing with colleagues on large renewable energy projects. We're exploring in this project the construction and the meaning of evidence and the role of different participants within the process, including publics and including experts. And as I've been reading the decisions, the planning decisions on big renewable energy projects, as I've been reading the decisions as part of this project, the importance of landscape and seascape has been really striking to me. Partly it's been so striking because this topic is so little discussed by lawyers. Lawyers don't really talk about landscape very much. And I was surprised, I was certainly naively surprised by the dominance of technical expertise on landscape. I had assumed that landscape might be one of those issues that is more accessible to human intuition, to lay experience, to local experience of the world. So seascape and landscape, I think, emphasize one of the perennial tensions that we witness in environmental law, the perennial tension between expert and lay public claims to influence decision-making. And that expert-lay tension brings us to questions of knowledge and claims to know things. From a lawyer's perspective, what we know at the end of a process is important, partly because it's an element of providing adequate reasons for a decision. Good reasons need to be provided for any decision, reasons that are both legally and, broadly speaking, socially acceptable. And one element of that reason-giving process is factual. And so landscape, seascape, becomes a fertile area for thinking about ways in which the planning system, and planning law particularly, knows how law receives different knowledge claims and how it accepts some of them as things we know about the world for the purposes of making a decision. Now we, as I mentioned, are interested in big wind farms, okay, big renewable energy projects. We're looking at nationally significant infrastructure projects in the legislative terminology, or NSIPs. NSIPs are decided through a special process under the Planning Act 2008. They're not decided under normal local planning procedures. I'm not going to run through the whole statutory process, just to say that an application for development consent is made to an examining authority within the planning inspectorate, so a government body, to the examining authority within the planning inspectorate, and the examining authority reports at great length with recommendations to the Secretary of State. The Secretary of State makes the final decision. So from now on, when I refer to reports, I mean the reports of the examining authority that are sent to the Secretary of State. These reports are not binding, but their detail and the sheer bulk of them provides them with quite considerable levels of authority within the process. And actually, the reasoning and explanations of the report are generally understood to be the reasons and explanations for the final decision. So these big documents are good places to look to see how knowledge is received within the process. And looking closely at a small number of decisions on nationally significant wind energy projects brings out, I think, the very laborious nature of the construction of knowledge in law. Knowledge for the purposes of making these decisions, knowledge about landscape, isn't just out there waiting to be discovered. I think in these cases, what we see is a very considerable effort to construct something that will satisfy everybody, or most people, as objective, consistent knowledge on a topic, landscape, that seems irredeemably subjective and ad hoc. By objectivity, though, I don't really mean neutral and inevitable, universally applicable facts, and I don't mean a state of mind, I don't really mean disinterestedness. Sheila Jasanoff, and we'll come back to her, refers to objectivity as a highly sought after, hard-won epistemic achievement. And I think this engages with the idea that claims to know something objectively enough for legal decision-making is effortful, but it's also crucial if we're going to have these legitimate decisions at the end. So achieving something that we more or less agree to be objective knowledge for these purposes, for now, is at the heart of the decision-making process here, and it's a hard-won social achievement when it works. Now, I will refer to occasional other decisions, but my main case study for this piece of work is the application by Navitus Bay Development Limited for up to 194 wind turbine generators off the Dorset and Hampshire coast. In England, the Planning Act Nationally Significant Infrastructure Project only applies to offshore wind farms, not onshore wind farms. So actually, whilst I'm talking about landscape and seascape today, the issue is more often seascape in this report. And obviously, there are some differences between landscape and seascape, but I think for current purposes, we can talk about them together and in very similar terms. Now, Navitus was rejected. This was not granted development consent. It was rejected by the Secretary of State following the recommendation to reject by the examining authority. And the rejection was made, as you can see there, basically on visual and more broadly on seascape and landscape grounds. Now, it's interesting that Navitus was rejected on these grounds, because actually these large wind farms always raise significant, strongly expressed concerns about landscape. And official national policy for nationally significant wind projects contains a very strong presumption in favour of consent. The policy context provides a context in which landscape concerns can actually be very easily dismissed by the decision maker. And yet, before Navitus, all nationally significant wind farm applications were consented. Okay? It was about a dozen, it's not hundreds. So this is the first case that was rejected, notwithstanding in other cases equally or even more strongly expressed concerns on seascape grounds. Now, maybe Navitus was just uniquely bad. Okay, maybe it's the unique physical characteristics of the location. Or maybe, and I wouldn't want to argue for any simple straight line here, but maybe there were distinctive patterns of knowledge claim in Navitus. Okay, so maybe it's because the technical and expert knowledge claims made by the applicant were very robustly challenged in their own terms in the Navitus case. More robustly challenged in their own terms, so on a technical expert basis, than perhaps in some of the other wind farm applications. Also on knowledge, the knowledge already in the system about this particular landscape, the knowledge already in the system, what I'll later call prior institutional knowledge, was also distinctive in this case. The wind farm in this case would have affected the setting of a World Heritage Site. Or maybe Navitus reflects a shift of government attitudes towards wind farms from enthusiasm in 2008 when the Act was passed to something verging on hostility now. Now, that shift in policy is simply not reflected in the formal policy applying to wind farms, but it's easy to imagine how that shift in government policy might mean that arguments are heard differently within the decision-making process. So decision makers may be more alert to the problems with a particular application. So it's an unusual refusal, and I can't give you a simple answer as to why it was refused, but it might be somewhat about knowledge and the way knowledge was used in the case. Before I go into the Navitus decision, just a word about landscape. Now, there is an absolutely enormous literature on landscape in all disciplines other than apparently law at the moment. And I can't do anything like justice to that literature. Some of you will know it much better than me. The important point, and we have a nice quotation from Simon Sharma here, the important point is that landscape is not only literally human-made. We made it, we built stuff, we farmed, we cut down forests. It's not just literally human-made. It's also historically, culturally, socially, I would add legally, constructed. And in turn, that landscape contributes to the shaping of cultural and social, and I would add legal, life. Further, landscape is not simply physical or visual. Further, landscape is dynamic. Our understanding of landscape will change. And the meaning of landscape is, I think, partially constructed within the very process that analyses it. And that includes the planning process, of course. So landscape also resonates with ideas of place attachment. And I've put you a quotation up there, a complex phenomenon incorporating an emotional bond between individuals and groups and the familiar locations they inhabit or visit. This quite powerful mix of issues within the idea of landscape or seascape suggests, I think, that there will be very special issues for achieving the knowledge of landscape that is necessary to make a good decision. By good, I mean legally and socially acceptable at a basic level. It's obviously a bit more complicated than this, but I think it's reasonable to start from the proposition that examining authority reports tend towards a somewhat reductive focus on the physical, visual, aesthetic landscape rather than the symbolic, cultural, or lived landscape. Okay? In Navitus, for example, the examining authority explicitly declined to include a sense of place as a principal issue for discussion. The examining authority said sense of place is important and it's included in lots of our other principal issues, but they don't refer to place attachment or sense of place at all again in the report. Okay? So I think the examining authorities focus on the visual, the aesthetic, the physical. Now, to examine this case, I developed 4 somewhat tentative categories of knowledge claim about landscape. I would not want to suggest that they are uncontested or that they can easily be separated from each other or from other non-knowledge claims. But I hope they're somewhat helpful to analyse the decision. So at the top, we've got 2 very familiar categories of claim. We've got expert or technical knowledge claims, and we've got lay, in this context, often local knowledge claims. And I've added 2 further categories. By a prior institutional knowledge claim, I mean knowledge that has already been absorbed within the system. In this case, that largely takes the form of a statutory landscape designation, such as, for example, an area of outstanding natural beauty. And these prior designations, these prior knowledge claims, say to the decision maker, stop, we already know something about this landscape, and you can just take that knowledge. My 4th category comprises the professional knowledge claim of the expert planner, in this case, the examining authority. Okay? So they're the 4 claims. My intention today isn't to suggest that we've got it wrong when we use these different categories, or that in a better way of decision making we'd give different categories of knowledge greater or lesser priority. My intention is simply to explore the resonance of these different ways of talking about landscape and seascape. And some of you will no doubt be wondering what I mean by knowledge. Now, my aim is to pull that from the reports rather than to start from a definition. But if it helps, I'm particularly concerned with claims to know relevant facts about the world. And I know that that category itself begs all sorts of further questions, but it's a claim to know facts, not with certainty, but with sufficient rigour to say, now you can take your decision, now you can move on. I start from the assumption that knowledge is plural and contested, it's not monolithic and self-evident. Knowledge is embedded in social processes, including planning. It's not out there in the world. But I must also accept that the contested nature of knowledge extends to the categorization of inputs to decision-making as knowledge claims at all. Okay, some of the things I'm saying are knowledge claims. You might say, that's not a knowledge claim, that's an emotional claim or an aesthetic claim or something. I'm not especially interested in insisting that anything in particular is knowledge, partly because I don't think we can draw firm lines between knowledge and not knowledge. I think we'd just get into an endless debate about that. But also because even the least likely propositions within the process often are implicitly raising an epistemological disagreement. So, for example, we might be saying that the applicant's experts' claims to know this landscape are wrong. We might just be resisting their knowledge claims. Explicitly, if local people provide their own alternative expertise. Implicitly, even in lay or more intuitive expressions of landscape. And in any event, if we understand landscape as more than a physical thing out there, but as something dependent upon past, present, future human relationships and understandings, well then lived experience, these lay propositions, partially make the facts that we seek to know. So let me turn now to Navitus. Now, first on the prior institutional knowledge claims. Most reports, I struggle to think of any legal processes that don't use this sort of knowledge. In this case, it's generally the form of a designation of part of the area affected by the wind farm as an area of outstanding natural beauty or a national park. A distinctive feature of Navitus was the impact of the project on the setting of the Jurassic Coast World Heritage Site. A simple conclusion on prior institutional knowledge claims is that they are very heavily relied on in every report. And these claims are potentially very important resources for decision making. They do at least two things in this case. First of all, they potentially enrich the notion of landscape beyond the visual and aesthetic. Any embedding of texture and experience within the designation makes that texture and experience available to our decision-making process in ways that would otherwise be extremely difficult. The second thing they do, which is more simple but equally important, is that they settle questions of aesthetic value, because questions of aesthetic value are hardly straightforward otherwise. But equally, I think this reliance on prior institutional knowledge can miss a lot of what is interesting about landscape. The enriching potential depends on the qualities of the process through which the designated landscape was designated and is now managed. The statutory definitions are spare and they are fairly shallow. So, for example, an area of outstanding natural beauty is an area of such outstanding natural beauty that the provisions applying to an area of outstanding natural beauty should apply to it. In the statute, that's it. That's an area of outstanding natural beauty. And not only is this sort of amusingly self-referential, but it assumes we all know what natural beauty is. You know, it takes that as self-evident, and it clearly isn't. But it takes time for an area of outstanding natural beauty to be designated, and there are lots of people involved in it. So these processes have the potential to bring in richer ideas of landscape. But they don't necessarily, and one of the important points is that that ambiguity around the meaning of landscape is hidden in the Navitus report. It's never discussed, and we render landscape both mysterious and kind of frozen at the moment of designation. Expert technical knowledge claims. This sort of knowledge claim dominates the reasoning in the reports. The applicant's seascape, landscape and visual impact assessment is the primary resource, but it's heavily discussed. I hope it goes without saying that this is not value-free, but this sort of knowledge claim uses consistent language and benchmarks. It self-consciously aspires to objectivity. The methodologies used are often approved in planning policy or in professional good practice. We use a lot of visual artefacts, maps, photos, and a cool technical language of classification. Importantly, in Navitus, we had a very well-resourced local group, Challenge Navitus, that provided competing technical expertise that competed on equal terms with the applicant's technical expertise. And this was heavily relied on by the examining authority. Now, lay knowledge claims, in a way I can deal with those very quickly because they were just silent in the Navitus report. The Navitus report didn't really refer to the lay intuitive expressions of landscape, such as were submitted, as you can see on the slide. The examining authorities speak to these intuitive issues much more carefully when they allow a development. They're much more respectful about saying, we hear your pain, but actually it doesn't outweigh the need for the great big wind farm in the sea. So they're much more respectful about this when they consent to a development. But in Navitus, this was almost silent. Turning to professional planning knowledge claims, this is the examining authority's own planning expertise, and it's a very significant resource. Site visits and the way the report talks about them are especially revealing. They have a very direct influence on the reasoning, and the examining authority draws very confident conclusions from its visits. So the applicant, for example, said, there's a lot of shipping here. It's a kind of industrial landscape anyway. The examining authority said, well, I went and had a look, and I didn't see a lot of shipping. Okay, it's just as, almost as simple as that. These visits also enrich the knowledge on landscape because they take us beyond the visual. So the examining authority might speak of tranquility and openness, the non-visual element of landscape. So there are 4 types of knowledge claim. They're all important and they're all used, except for the lay and local knowledge claims. Any conclusions I might draw are firmly rooted in this context. It's a landscape or seascape impact of a nationally significant, going through that special process, wind energy project. In a sense, that's the point. The point is that knowledge, for the purposes of providing reasons for a decision, is constructed within a very particular legal and social process. But equally, there's a little bit of broader food for thought. The preference for expert or technical knowledge over lay, and in our case, local knowledge, is a very familiar theme in environmental decision making. We see this everywhere from waste to pesticides to genetically modified organisms. To see it repeated here in this especially striking context where we'd think that you might get more intuitive contributions reinforces our existing understandings, I think, of that pattern. Prior institutional knowledge and professional planning knowledge is less discussed in the legal literature, but it's a feature of many, if not most, administrative processes. The precise contribution of these different things is likely to vary, but I'll say a few things about them in any event. So, prior institutional knowledge provides a level of stability on difficult value judgments, in this case including aesthetic judgments. The designation process may, but as I said before, may not, have embraced richer understandings of landscape than this regulatory process would have been able to. And if so, there might be some additional complexity and richness in our understanding of landscape. Something is lost, at least the dynamism and the particularity of our construction of landscape. It's not really surprising that professional planning knowledge claims are important, notwithstanding all the other evidence, because ultimately planning decisions are a matter of planning judgment. Here, I think this is especially interesting for the way it interacts with those lay and expert areas of knowledge. The space for planning judgment, I think, creates an opportunity to allow lay knowledge to speak, to allow local people to speak of their landscape, and to provide the supportive reasoning for these professional claims. But the examining authorities are resistant to that. They prefer technical evidence to support their expertise, and they prefer their own impression of a site over the lived experience of local people. The three types of knowledge claim that feature in the reason-giving process, so I've dropped the lay claims out now, I think might be part of the same effort to construct a particular objective knowledge for the purpose of legal reason-giving in this really tricky, apparently subjective and ad hoc area. Prior institutional knowledge removes some of the political controversy over value to another forum. It provides a very neat and tidy set of facts to use. One of the familiar functions of highly technical approaches is to be seen to achieve consistency between decisions and between decision makers, and again, to step back from political controversy. And professional knowledge claims may speak to a similar assertion of emotional distance and shared professional values. But coming back to Sheila Jasanoff, I don't think that the knowledge about landscape is asserting the facts pure and simple. I don't think it's saying we understand this landscape now and we understand it forevermore in one single acceptable way. They're saying this is serviceable truth. This is true enough. This is a stable and acceptable enough set of facts to allow the process to go forward. And the three types of knowledge layered through the report bolster each other to give a vision of landscape that's relatively rich, it's imperfect, but it's relatively defensible and serviceable as a vision of landscape. So far, under the Planning Act, it more or less works in that these outputs are socially and legally acceptable. We can imagine a situation in which the disagreement continues to be disruptive after the decision-making process is supposed to have been resolved. The only claims that are consistently silenced are those lay and local claims. And I suppose we have to ask ourselves what that tells us about participatory planning processes. I should emphasise that that's not my intention. My intention wasn't to advocate for any particular approach or to argue for the reorientation of our knowledge claims. My intention was to explore the complex dynamics of these extraordinarily richly documented decisions. And I think a simple conclusion is that the very laborious nature of the construction of knowledge is very apparent when we try to understand the role that landscape and seascape are playing in legal decision making. Thank you very much.
Thank you very much. We have a couple of minutes for questions, if we have any. We have one here. Could I have a mic? This gentleman here.
Hi, thank you very much. This is a very interesting lecture. I'm just wondering, with your conclusion that there's an absence of local input into these decisions, how important is a local input compared to a lay input? Specifically, if I live in an area of outstanding natural beauty, do I have any more ownership of it than the visitor? And why would local knowledge have more weight over just general lay knowledge?
It's a good question, and Challenge Navitus included, so the protest group essentially included a lot of local people. So it's not that local people had no say, it's that they had to frame their contributions in a particular and very demanding way. Okay, so they had to frame their contributions technically in, competing expert evidence. So local people did have a say. What was absent was this, these intuitive ideas about the iconic nature of the landscape and not wanting an industrial landscape to be imposed on what had previously been a natural landscape. And in terms of whether local people should have, which I think is your question, should have more of a say than others, well, I suppose the only answer is it will depend, won't it? It will depend on the nature of the place that you're talking about, and it will depend on the nature of the connection of the visitors. And often those interests will coincide, if only economically, if the area is getting a lot of its economic development from visitors. So it's not an easy question to answer. I mean, I'd say sort of impressionistically that these reports do prefer local people to be making these contributions and do seem to value them more, but it's very impressionistic, and I haven't seen it argued in these cases.
Thank you. We have a gentleman over here and then a Slido.
Hi, thanks for the lecture, Maria. Building on the previous question, in any discussion of local or lay knowledge that you've come across, has there been any reference to the difference of generations? Particularly I'm thinking in the contrast between Wales and England as far as planning decisions are concerned, and the way that different views of wind farms are reflected by the normalisation of them to younger people more than older generations.
That's an interesting question, and I'm sure there is an enormous literature on it, which my colleagues at the back are probably very aware of. They're shaking their heads, so maybe there isn't an enormous literature on it. So I'll just say I'm not familiar with that, but there is some work that says that essentially people get used to wind farms. So when you've had it there a while, people's level of upset declines. But that's not surprising, and we have got some cases where local people are resisting the third or fourth or fifth wind farm in their area. Their level of upset does not decrease. They start to talk about being victimised. Okay, so I think it will vary a great deal. Thank you.
A Slido.
This question leads on kind of nicely from the previous. Is landscape therefore something that is more nostalgic, the maintenance of what has been, rather than ambitiously creating landscapes for the future? And I guess tag-on question is, do you see that reflected anywhere else in law, that it's, about what has been as opposed to creating something new?
I think landscape and the way people talk about landscape could be nostalgic, and it depends, I suppose, on what people value about their particular landscape. So sometimes it will be nostalgic, but sometimes it will be future oriented. Sometimes it will be very much looking forward. And the article that I put up there earlier, actually, I didn't put it up for this purpose, but that article, the Devine Wright article, contrasts two communities' understandings of a proposed wind farm, depending on whether that community viewed itself as a special place with a beautiful landscape and restorative and valued, or viewed itself as run down and depressed and was hoping for a bit of an economic boost from the wind farm. So it will definitely vary. Do I see nostalgia in law? I'm going to have to think about that a lot more, I think. Sometimes, no doubt, and sometimes not, no doubt.
Well, thank you. I think we don't really, unfortunately, have any more time for questions, as we have to be out of here at 5 to 2. But I'd just like to ask you to join me in thanking Professor Lee once more for a very interesting lecture.